Hello, I'm Lieutenant Colonel Alan Wilson. The following briefing addresses the Lautenberg Amendment and whether or not you, as a member of the military, may possess a firearm. It is extremely important that you pay attention to what I'm about to say. If you believe that the information contained in this briefing could apply to you, then you need to notify your chain of command immediately and seek counsel from a legal services attorney. The 1996 Amendment to the Gun Control Act, known as the Lautenberg Amendment, and DoD policy prohibit an individual who has a qualifying conviction for criminal domestic violence from possessing a firearm or ammunition. There is no exception for military personnel. First, you need to understand what qualifies as a crime of domestic violence. Domestic violence is the use or attempted use of physical force or the threatened use of a deadly weapon committed by a soldier against a current or former spouse, child, or another similarly situated person. A similarly situated person could include stepchildren or a cohabitating significant other. If you have been convicted of an offense like assault and battery, and the facts of your offense support the elements of domestic violence, then this may apply to you as well. Just because the offense does not have the words domestic violence does not mean that you are off the hook. Next, you must have a qualifying conviction of criminal domestic violence in order for this firearm prohibition to apply to you. A qualifying conviction includes, number one, a conviction of a criminal domestic violence charge. Number two, a general or special court-martial conviction for an offense that meets the definition of domestic violence. Number three, the soldier with the conviction must have been represented by counsel and convicted by a jury, or that the soldier at least knowingly and intelligently waived these rights in a guilty plea. It is important to note that if you went through pretrial intervention, also known as PTI, or some other diversion program, then this does not qualify as a conviction. Let's assume for a moment that you have a qualifying conviction for criminal domestic violence, otherwise known as CDV. This basically means that you have been convicted or pled guilty to CDV, and that at that time you either had an attorney or knowingly and intelligently waived your right to an attorney. The next question is, how does this affect you? You cannot possess, ship, transport, or receive firearms or ammunition, and a person who knew or had reasonable cause to know of your qualifying conviction cannot transfer a firearm or ammunition to you. So, if you possess a personal weapon, you may be committing a felony. If you receive an issued weapon or ammunition from your unit, you may be committing a felony. If someone in your unit, including the chain of command, knew or should have known of your conviction, and they issue you a weapon, then they may be committing a felony. Now, no one wants to be a felon or cause someone else to become a felon. So you say to yourself, I will notify my command so that no one gets in trouble. What are the practical effects of telling your command of this conviction? Well, you're now considered non-deployable for missions requiring weapons and ammunition distribution, as well as overseas or OCONUS missions. You cannot be assigned to leadership, supervisory, or property accountability positions that require access to firearms or ammunition. You cannot be sent to service schools where firearm instruction is conducted. Additionally, you will be flagged and barred from re-enlistment and likely administratively separated from the military. Whoa, this is serious stuff. So you're probably wondering, is there any way to avoid all of this for just being honest and reporting your conviction? The answer is yes. If you get a pardon or an expungement within a reasonable time, then you are treated as if the qualifying conviction never occurred. Commanders may make reasonable temporary accommodations for soldiers who are waiting for an expungement or a pardon. If you ever find yourself in a situation in which you are deciding whether or not you should report a qualifying conviction for criminal domestic violence, then remember that the consequences of not reporting are far worse than reporting. As a soldier, you have a continuing duty and obligation to report these kinds of convictions. In addition to the firearm restrictions imposed by the Lautenberg Amendment, you could also be prevented from carrying a firearm if an order of protection has been issued by a family court judge or magistrate which requires you to not contact or to stay away from a specific individual. This is also known as a restraining order. You would know about the restraining order because you were present in court when the judge issued the order against you, or you have been served with a copy of the order. This type of restraining order may prohibit you from possessing a firearm, even in military duty status. If you have this type of restraining order and you violate it by possessing a firearm, then you could be subject to federal criminal charges, which could result in jail or substantial fines. Only a certain type of restraining order prevents you from possessing a firearm. If you have a restraining order, then you should see a judge advocate to determine if that restraining order would bar you from possessing a firearm. Also, this type of restraining order typically lasts for a fixed period of time, so carefully check the date on the restraining order to determine if you would be in violation for carrying a firearm. If you have a question in this area, you are highly encouraged to see a judge advocate. This briefing is not intended to be a comprehensive course on Lautenberg Amendment and DoD policy. If you have any questions whatsoever, then you need to seek legal counsel from a judge advocate immediately. When in doubt, it is always better to ask than not ask. Thank you for your attention to this very important brief, and good luck.